developments 1 week after a mistrial was declared.
I'm declaring a mistrial in this case.
Karen Reed's team moving to dismiss 2 charges against her, including murder.
This is what it looks like when you bring false charges against an innocent person.
Plus, a status hearing for Trooper Michael Proctor.
It's fair to represent this as a mini trial.
Has led him to be suspended without pay. What this could all mean for the future case against Karen Reed.
All of that is at play for the investigation.
Canton Confidential, the Karen Reed murder trial, starts right now.
It may have ended with a mistrial last week, but the Karen Reed case continues to grab headlines. Good evening and welcome to a special edition of Canton Confidential. I'm J.C. Monahan.
I'm Glenn Jones. There were 2 major developments today that led to this moment. The first, Reed's lawyers filed a motion to dismiss 2 of the 3 charges against her. Her defense team says 3 jurors reached out and said the jury reached a unanimous not guilty verdict on 2 of those charges. The second-degree murder and leaving the scene of a fatal crash. According to the defense, it's the 3rd charge, manslaughter while operating a motor vehicle under the influence of liquor, that had the jury divided.
Also today, the lead investigator in the case, State Police Trooper Michael Proctor, has been suspended without pay. Proctor was already the subject of an internal investigation after sending vulgar texts about Reed to his family, friends, and fellow troopers. We'll have much more on that in just a moment. We want to begin, though, with the motion by the defense to toss out 2 of the charges against Karen Reed.
If this motion is successful, only the manslaughter charge would remain. NBC 10's Darren Botello takes a closer look at today's surprise move by the defense.
Karen Reed's attorneys on Monday filing a motion here at Norfolk Superior Court to dismiss 2 of the 3 charges against Reed, the second-degree murder charge and leaving the scene of a fatal crash. We obtained the motion, you can see here, saying in part, quote, counsel began receiving unsolicited communications from 3 of the 12 deliberating jurors, indicating in no uncertain terms that the jury had a firm 12-0 agreement that Miss Reed was not guilty of 2 of the 3 charges against her, including the charge of murder in the second degree. The defense now arguing to prosecute Reed again on those charges would be double jeopardy. Before a mistrial was declared, though, multiple notes were handed to Judge Beverly Cannoni, our legal experts saying with no indication that the jury reached a verdict on any of the charges.
The note that was submitted to Judge Cannoni said that they were hung on the charges, plural. The question is, why then wasn't the form completed at all? Because there were spaces, certainly for the second-degree murder charge, for them to have checked off not guilty.
In hindsight, legal experts we spoke with say Judge Cannoni could have gone through all 3 charges with the collective jury before a mistrial was declared, with Reed now still accused of hitting her Boston police officer boyfriend John O'Keefe with her SUV, leaving him to die in the snow in January 2022.
Judge Cannoni would decide whether an evidentiary hearing can be used in order to gauge whether the jurors met and reached a consensus on any of these counts.
So we contacted the DA's office. They say they're looking at the motion in anticipation of a filing response and look forward to picking a new trial date on July 22nd. In Dedham, Darren Botello, NBC 10 Boston.
Well, I saw him as recently as Friday, and I didn't know I'd be seeing him again so soon. Let's bring back in Michael Coyne, Dean of the Massachusetts School of Law, to go deeper into all of this.
Michael, as always, thank you for being with us. The argument is to dismiss counts 1 and 3. So we're told the defense learned of the jury's vote because one of them reached out directly to David Yannetti, and then 2 more jurors emerged with the same information. Have you ever heard of someone on a jury doing this before?
No, it's highly unusual that jurors would come before the verdict has now been entered in the record to come and say, you know, that wasn't really our verdict at all. It's incredibly unusual, as is this case from beginning to end. And as we see now, the end is not as near as we thought. So it's a highly unusual step. Sometimes jurors will come and contact lawyers and say, what about this or what about that? But it's unusual where they've returned a verdict without any indication of guilt or not guilty on it, and now say, well, we had reached a verdict on a couple of the counts. So the Judge Cannoni has a real issue before her because it's very difficult to go in and try to impeach the jury's verdict because we want those deliberations to be sacrosanct. We don't want the jurors' internal discussions generally examined, and that's the law in the Commonwealth, and it's very difficult to even get a hearing with respect to the question about what took place during the jury deliberations.
Well, Michael, a lot of our astute viewers asked us, why wasn't the jury polled before declaring a mistrial? What are the rules regarding that?
Generally, the court doesn't want the jury polled. They don't want to invade the jury's space, in essence, to ask them to reject their conscious decision individually. She could have asked them generally, do you all agree that you can't reach a verdict on count one? Do you all agree that you can't reach a unanimous verdict on count two? But you would have wanted to do it generally like that to the entire veneer, not just individually ask each juror what their vote was, because that can be an intimidating tactic if she had chosen that route. And it's not just disfavored. It's not supposed to be done under the law.
Okay, and Michael, I need some help with this one. How can anyone on that jury, find her not guilty on the third charge, but be split on the second? I mean, if you think she's not guilty of the lowest charge, leaving the scene of personal injury or death, wouldn't she have to be not guilty on count two, which is manslaughter while under the influence?
Yeah, excellent point. And that's what I was thinking as well. I can understand, we've talked from the outset that with respect to second-degree murder, the case really wasn't there and was likely going to be a not guilty. So that part of it makes sense, that the jury may have said, let's discard this. No one really wants to fight for it, and let's focus on the last two charges. The problem is that if they were at one point 6-6 on vehicular manslaughter, and then ultimately even as far as 8-4 on vehicular manslaughter, that she caused his death with that vehicle, well, how can they then reach a unanimous verdict to the contrary, that she didn't leave his body there as a result of the motor vehicle coming into collision with him and cause his demise under the circumstances? That's very internally inconsistent. I would expect that the Norfolk County District Attorney's Office will point that out, that some of the information we've had just doesn't hold together when you examine it closely. And that's a particular one. You know, the fact is that's the least of the most serious charges, but I don't know how, if you're finding not guilty on that you could look at it as an 8-4 guilty on vehicular manslaughter.
Exactly.
Yeah, so confusing. Well, so if we look back to the moment that the mistrial was declared, could the defense have done some of the things in the courtroom that now they're claiming in the motion?
Another really good question, and I think the answer is yes. If you wanted clarification, you could have asked the judge, Your Honor, would you make sure that the jury is, in fact, hung on each and every charge that they face? But, you know, that's one of those ones that maybe you don't want to ask the question you don't know the answer to, because maybe they'll say, well, no, we have a verdict on X, Y, or Z. So that could have been done. They could have asked. And remember where we were when she declared the mistrial. We had a series of notes. We had the note that morning that really indicated, if you were reading it carefully, that they were likely hung. They still went out 4 hours later, tried some more, got their final instructions, and still failed to reach consensus. And then the note was incredibly strong that they were never going to reach consensus on the charges, right? It's a plural that the note said, and she read it out loud, and it said it twice. So it wasn't a mistake, at least it would appear by whoever wrote the note, that they were indicating they were hung on the charges before them, and there were the three main charges and some subsidiary charges. So I think if we look back at the time, I guess we could have asked for clarification, or they could have. But at the bottom line is, though, the notes were very clear that it appeared to everyone observing that they could not reach consensus on anything. And that's where it gets interesting, because at least some juror has now said, well, we did have consensus, but the form isn't completed at all. The very first question that they could have answered said not guilty with respect to the second-degree murder charge. And so it's not buried deep in the form. It wouldn't have been difficult if, in fact, they reached consensus. It's a very interesting problem that Judge Cannone has now, because at least we have some jurors coming forward saying there's a problem, but we don't have a majority of the jurors, and we certainly don't have them all saying, oh, no, we had agreement.
Michael, we have 2 seconds left. I'm going to put you on the spot. Would you retry this case if you were the prosecutor?
I think you have to on behalf of the O'Keefe family, as well as you have the murder, at least as the prosecution sees it, of a Boston police officer. And at some point, we should have justice for John O'Keefe. And that's the way the prosecution sees it, is this is the correct defendant.
Thank you so much for joining us, Michael. We always appreciate your input. Thank you. All right, coming up next, more legal questions with attorney Morgietta Dourcier.
Plus, we have the latest update on the status of Michael Proctor, that Massachusetts state trooper who investigated the Karen Reed case. Stay with us. Welcome back to this special edition of Canton Confidential. We want to continue our discussion on the defense team's motion to dismiss 2 of the 3 charges facing Karen Reed, including the murder charge.
Her attorneys claim that the jury had unanimously concluded she was not guilty of either charge. We want to bring in Morgietta Dourcier, legal expert and lawyer at Bay State Law Group. Morgietta, what happened here? We were just talking to Michael Coyne, and he said the jury form itself was pretty clear that there was after second-degree murder, there was a box right there to check not guilty. Is this simply a matter of a confusing jury form or confusing jury instructions?
I think it's a little bit of both here. And I think the reality is that the entire case was confusing to the jury, right? And even confusing to us. So I think it breaks it down into 2 important pieces. Number one, the jury form may have been confusing, although I would agree with Michael that count 1 and at least count 2 appear to be pretty straightforward on the form. And maybe they were hung up on the lesser included offense in count 2, right? But the second piece of that is they were given the actual jury instructions, which could have been about 15, 20, maybe 30 pages long. And that may have been confusing because sometimes these jury instructions seem straightforward to certain experts, but may be confusing to the general public because there are sections of it that could sound contradicting, right? And so you have to navigate that as well as the facts that you have on hand.
So when the trial journey is confusing, does it come down to the judge being the tour guide to kind of clear up the confusion? I think broadly speaking, Judge Cannoni has come in for good marks on this case, but when we dig deeper into these issues, does some of the blame lie with her?
So the judge's position is to instruct on the law, right? But she can't make or change the law. She has to read the law as it is. And it's up to the jury at that point to decipher with the law that she has given, can they apply those specific facts? Whether or not it comes off confusing or not, I think it's for the jury to really understand what they understand. And I think I've said that from the beginning, that they are the trier of fact. They're the ones that have to interpret what they saw as factual and apply it to the elements of the charges that Karen Reed is being, charged with. It may be confusing to them overall, but a lot of them is from my understanding. I think I've heard that this is the first time they've sat on a jury. So I'm not surprised that they've reached this point where they're coming back now, or a few of them are coming back and saying that some of the information wasn't clear.
Morgietta Dourcier, thank you so much for your input on this.
When we come back on Canton Confidential, a hearing for the state trooper at the center of this case.
Our Eli Rosenberg joins us live with today's decision on Michael Proctor's future with the state police.
This is Canton Confidential, the Karen Reed murder trial. State police handed down the punishment today for the lead investigator in this case, Trooper Michael Proctor.
A board of commissioned officers recommended that Proctor be suspended without pay, and the interim superintendent agreed. Eli Rosenberg joins us live from South Boston with reaction to this decision. Eli.
Well, JC, there were 4 possible outcomes from this duty hearing involving Michael Proctor today, and this one, the suspended without pay, the most severe. As again today, right out here in South Boston, we were reminded just how divided people are over all of this. In South Boston, voicing their displeasure on a day the state police moved to suspend without pay the lead investigator in the Karen Reed murder investigation.
I don't like they say angry. That's just not my vocabulary, so I use motivated. People are motivated for change in the Massachusetts State Police.
Last week, within hours of Karen Reed's mistrial, state police announcing it had relieved Michael Proctor of duty. That setting the stage for today's duty status hearing.
These are internal proceedings. There's nothing involved with the DA. There's nothing involved with any other outside entities.
Todd McGee is a security analyst and served as a state trooper for 24 years before retiring. He says as a trooper, Proctor is entitled to this hearing through the Troopers Union, something we are told happened virtually today with Proctor meeting with 3 commissioned officers.
All of this information to include what transpired in court during Trooper Proctor's testimony.
This is me speaking on June 9th.
And McGee says that testimony in open court makes this case much different than the ones usually conducted by state police internal affairs. In the end, the board finding Proctor should be suspended without pay, a recommendation accepted by the head of the state police around 2 this afternoon.
There's a lot of things that are happening behind the scenes. There are a lot of layers to this type of a process. But certainly this is, for an administrative proceeding, what we would call due process.
And the event out here lasted about 2.5 hours. JC, we did reach out to Michael Proctor's lawyer for reaction to everything happened today. We have not heard back.
Eli, before you go, we just want to share a viewer question about this with you. Robin D. asks, now that he has been suspended without pay, exactly how long is that suspension and what happens next? Can you answer that?
The state police did make that clear today. The answer is we don't know. The internal affairs investigation, according to state police, continues, and they did not provide a timeline for when that may be wrapped up. JC.
Wow. All right, Eli Rosenberg reporting from South Boston. Thank you. One, of course, of the tragic outcomes of a mistrial is the delay of justice for the victim's family.
Still ahead here on Canton Confidential, what we learned about John O'Keefe from his loved ones who took the stand. In case you weren't able to join us on Friday, we wanted to circle back to a piece we highlighted about the victim in all of this, John O'Keefe.
One thing holds true. The justice system has not yet held anyone accountable for his death, and his loss is especially difficult for his family, which has already suffered so much heartbreak.
The world knows John O'Keefe as a proud Boston police officer of 16 years. The people who knew John intimately call him Johnny and say the job he loved most was being legal guardian to his niece and nephew.
Johnny moved into their house in Canton, the original house that Steve and Kristen had bought. He moved in with the kids there.
John's older sister, Kristen, tragically died from an illness, and just months later, her husband died too. Their kids were orphaned. A little girl aged 6 at the time, her brother aged 3. The O'Keefe family, in court every day of the trial, was devastated.
My wife and I had talked about having the kids come live with us. We had 2 small children at the time. 3 and 8 months were my children. We didn't have a, large enough house to take on 2 other children, so my brother stepped in, moved into the house in Canton, and raised them for 8 years.
From 2013 up until his death, John O'Keefe loved the kids as his own and would constantly show up for his friends' families too.
We were close. We did a lot of stuff together. Pick up the kids, drop the kids off.
Him and my husband would always do the games. The kids used to call them my 2 dads. It was like they had a lot of fun together.
John's friend Michael Camerano on the stand said he'd go to the O'Keefe's household every Friday night. He knew John and all of his personality traits.
Everything was very tidy. When you walked in the door into the house, to the left, you put your shoes, your coats would be hung there.
And as far as shoes were concerned, is that something that you wore inside the house or not?
He'd rather you not.
That day in January, John and Michael both had something to celebrate. The kids got school acceptance letters, a proud dad moment.
We were just congratulating the girls, talking about how good it's going to be, different school, and just really excited for the girls.
Another close friend testified later in the trial, Laura Sullivan. She dated John's friend Pat, became pregnant with Pat's child, but in 2013, Pat took his own life.
Immediately following that, John never really left my side, as a support system.
John would become godfather to Laura's son, another way John O'Keefe stepped up for his friends' families, for his own family. He was 46.
Thank you for joining us for Canton Confidential. I'm JC Monahan.
And I'm Glenn Jones. Our coverage will continue as this case develops throughout the weeks and months ahead.
And we know many of you still have questions. We want to help get you those answers. So if you have a question, please email us at canton.confidential@nbcuni.com. We hope to answer it right here on air or online.
And remember, you can catch up on previous editions of our show. If you have missed any of them, they're on our website, as well as a podcast that you can listen to wherever it is that you get your podcasts. For tonight, that's it for Canton Confidential, the Karen Reed murder trial. We'll be back with you whenever news warrants.